going black. Cutting in and out. What is happening? Is somebody in front of the camera? I don't know what this means. It's on. Come on, Jean. All rise. The Honorables, the presiding judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the Court of Appeals. I'm Judge Donna Stroud presiding today, and to my right we have Judge Valerie Zachary, to my left Judge Toby Hampson, and we have two cases for argument today. Looks like y'all are ready for the first one, and were you going to reserve 5 minutes for rebuttal?
Yes, Your Honor. I prefer 5 minutes, yes.
Okay, and did y'all already have that set up on the timer?
Yes, I told her 10, but I'll go with 5.
Oh, no, you can do, you can do whatever you like. If you want to do 10, that's fine.
5's fine, Your Honor.
Okay, all right. And like I said, I'm not dictating anything. That's just kind of the traditional number, so, but people can certainly pick other numbers. So, just want to make sure that it was set up on the timer before we got going. Okay, all right, then we can proceed.
Thank you, Your Honor. May it please the court, I'm Jeremy Browner. I am the counsel for plaintiff appellant. Your Honor, this is the second trip up to the Court of Appeals for this case. This case has 6 theories stemming from 4 notices of appeal, 4 orders. The first issue is whether or not a motion to continue was wrongfully denied, and there's a primary and secondary theory on that issue. The second issue is whether a North Carolina District Court can enter an amended order after they've entered a skeletal order some 62 days later. Third issue is whether or not a skeletal order can order a military member, modify a child custody order based on whether a military member, based on their military service, when no findings of fact or conclusions of law discuss the best interests of the child. Fourth issue is whether or not the court can enter a springing contempt order for violating child support. Fifth appeal issue is when the trial court is ordering confinement due to a contempt, does it have to contemporaneously investigate the contemptor's current ability to pay?
Okay, well, let me start out. I just kind of want to, first of all, since we had the issue regarding the continuance, the court date, with the SCRA, it would seem to me, wouldn't we sort of need to start, at least with the custody order, as to the review of that order?
Okay.
Because if that case were, if it should have been continued, then obviously that would impact the issues regarding the custody, right?
There's two theories on that, Your Honor. The primary theory is whether or not the trial court denied the state motion to continue, and that's under a abusive discretion standard. Of course, that's...
Well, I just want to talk a little bit about the standard of review. I don't see any cases from North Carolina regarding that, and I presume y'all didn't either, since I think they were from Ohio, Kansas, and Alaska, some of the ones that were cited. And so, under the SCRA, it seems, the statute says that if the service member makes a certain showing that the court shall, which tends to indicate something that the court is required to do, which tends to indicate perhaps de novo review. I just wanted to see if y'all had any thoughts on that.
My brief did say I think an earlier version, the Soldiers and Sailors Relief Act, had abusive discretion as well.
Right, I realize the older version.
But Service Members Civil Relief Act in 2003, Congress passed after 9/11, does not have any appellate law on standard review.
Right.
Not that I can find.
Okay.
But would it, I guess the question becomes, is compliance with the statutory requirements, is that an issue of law, or is it purely an issue of discretion?
It depends on whether or not this state will liberally construe that statute or strictly construe that statute. Certain states have liberally construed it concerning Supreme Court. The case from 1943 actually stemmed from a North Carolina case, and that was Boone versus Leiter. And that goes into detail about the prejudices of missing hearings and such in the trial, that there's a presumption of prejudice happening. And that also, and there's a second case, Leffers, that says that the statute should be read, of course this is the previous version, should be read friendly towards those who drop their affairs to answer their country's call, which is certainly the case here. So the issue that we have is we have a motion that's titled Motion to Continue, but it has all the elements for a Service Member Civil Relief Act stay.
Well, is there any difference between a continuance and a stay for purposes of the SCRA? I couldn't really find anything that indicated any difference.
Well, a continuance is you're asking the court on its own inherent power to continue.
I know what a continuance is, and I know what a stay is, but I'm just saying for purposes of the SCRA, I'm not really seeing a difference.
Well, the SRA will automatically impose a 90-day stay, first time, where a continuance you can come back tomorrow.
Well, which is in effect
Yes.
a continuance, whatever it's going
So a stay is automatically has a 90-day the first time you come to a court and say, I need 90 days.
And part of the requirement under the SCRA, as I understand it, is that there needs to be a statement of when the service member would again be available after
Yes.
after the deployment, right?
There is. And if the court would liberally construe that, then what you would look at is the table that was attached to the commander's memo that the court said that she looked at in another order. In the May 30th order, the trial court said, I looked at that when considering the motion to continue. And so if you literally construe it, you could say the inverse of that. These are the dates that the soldier has to be in mandatory training. What about the dates that are not on there? Those are the dates that he's available.
But then there's the email, of course, from the commander saying that he had to appear on the 27th, I believe.
I'm sorry, the microphone is not, it's behind your...
I'm sorry, the email from, I'm blocking
microphone,
that.
yeah.
Okay, I'm sorry. Thank you. The email from the commander regarding the date.
The email from the commander came in on Friday afternoon, with the hearing being the next Wednesday. And of course, there is a statute that protects a reservist, which I did not cite in the brief, but that's 50 U.S.C. 3917. And that says a member of reserve component who is ordered to report for military service is entitled to the rights and protections of this subchapter and subchapters 2 and 3, which includes the 3932 that we're looking at. During the period on which the date of the member's receipt of the order, that's the email, and the ending on the date on which the member's reports for military service. So it fills in the gap between the moment he gets the verbal order in the morning, he gets an email in the afternoon, he's asking for consent for the motion to continue, and files the motion to continue Monday afternoon. Court denies it Tuesday, they had the hearing on Wednesday.
Didn't the trial court work with your client to set this date?
They did, Your Honor. This happened, the way that Orange County does it, the chief judge, who's also the presiding judge in this case, has, in both Chatham and Orange County, she has a family law calendar day, which is the last Tuesday of every month. And so she brings in all the cases, and she assigns hearing dates and assigns a judge on that day. And that happened in late January of 2023. And my client was present and spoke at the calendar call and said that he was available on March 29th. But because the commander ordered him to come in earlier, that's why he needed the continuance. He needed the report. So now he's caught between having to listen to a lawfully issued order from his commander or having to come to the hearing for a permanent change in child custody. So he's caught between the two. Which one do I listen to? I put a motion of continuance in, but it's been denied. And that's exactly what the Service Member Civil Relief Act is supposed to stop, is that when someone drops their affairs to answer the country's call, because we have pre-certification for pre-mobilization, you have to take certain trainings before you're deployed to a dangerous environment, such as Africa, where he was going. There has to be, you have to look at this, and the judge, the trial court, has to determine that a stay is required here. We have, there's a dispute of whether or not he's in military service. I think I've solved that by showing that when you're in training, in full-time training, which the Army considers other training duty in their regulations, and for pre-mobilization training, that's considered full-time training.
Did he have to attend this training to make up for days he had missed earlier?
Yes, Your Honor. The days he had missed because he was incarcerated for contempt, and he had to have a certain number of training days in order to be certified to be deployment ready. And so the commander said, you need to come to make up for the days that you were incarcerated in January, because you missed some training during the January period while you're incarcerated for contempt. So he was required to show up earlier and his duty that day, he was helping plan the pre-mobilization training.
And of course, with the orders in our record, I have, the military speaks in acronyms, but my translation of the acronyms that I've been able to do, and my father was in National Guard for many years, so I have some familiarity with it. It appears that these were in fact dates that he would have to be when we're talking about the March 29th date, the 27th, 28th, these were dates that were mandatory training, it looks like.
Your Honor, it actually
Not
says
really.
on the memo,
Yep.
mandatory training, mandatory battle assembly. And then
Right.
there's a footnote on the bottom of that memo that talks about that you have to obtain permission from the commander or first sergeant to be released from that obligation.
Right.
So the second issue that the court may have is the conditions for stay. There's two things that need to happen. A letter or other communication setting forth the facts stating the manner in which current military duty entirely affects the service member's ability to appear, and stating a date when the service member will be available to appear. So we have a memo. We have from the commander saying it's very important that this service member show up. We have a table of dates. We have an email from the commander saying, I need you to show up early to make up timing because you're incarcerated for contempt. And so I think condition A, if you're going to liberally construe, you can back into that. B, a letter or other communication from a service, I'm reading from 50 U.S.C. 3932. A letter or other communication from service member commanding officer stating that the service member current military duty prevents appearance and that military leave is not authorized for the service member at the time of the letter. And so it says communication. So again, we had this memo from February that the court says in the May 30th letter, hey, I looked at that. And that memo says these are mandatory, and here, if you can't get out of it unless you get permission, so you can infer that leave is not authorized, especially if you liberally construe this. Now, and so then if you add that to the military order, the email that says come in early, and you add 3917, which is an extension to when the orders are issued, then you have complete coverage here. So attendance is mandatory unless split training is made at least 30 days prior. That's in the record is 118, by the way. Page 118 of the record is what I keep referring to. And mandatory battle assembly shows OTD for planning, preparation, executive, collective training missions, and pre-mobilization certification training. So that's the issue. And not to mention, we kind of have a clue of how the North Carolina Supreme Court feels about this issue, because I included a judicial commission case against a district court judge, because that judge did not use the Service Member Civil Relief Act, and there was a dispute. The soldier said, hey, I'm being deployed, and it was a default judgment situation, not a situation like here where we have a hearing and the service member has notice. But the Supreme Court was upset and admonished the district court judge and says, you didn't do your own research. You just blindly followed what opposing counsel said to you, and that you didn't follow the judicial canons. So that's not mandatory citation to you, but it shows you what the Supreme Court would be leaning towards. So that's the issue with the motion to continue. Moving on, the March 29th order is next. And what that was is trial court has a custom of entering the skeletal order that has no findings of fact and no conclusions of law. And we waited the requisite 10 days, and we filed a notice of appeal on April 25th, which was 27 days past the order date. And trial court under Rule 52B has the right to amend the findings of fact and the conclusions of law. The trial court did not avail themselves of that. Opposing counsel did not file a motion to modify it. So after that point, after that 10 days, it's our position that the court has no authority to modify that order anymore. So what happens now is you have...
Now, let me go back to the trial court's order that was originally done actually said that it was anticipating the preparation of a formal order, and I believe directed one of the attorneys to prepare that order and submit it by a certain date. Isn't that correct?
I believe that's, yes, that's what the trial court said, but that's in contrary, or that is in contravention to the civil rules. Because what you have then is which
Well, what
order do you...
rule are you talking about that would be in contravention of?
Well, if you put a skeletal order in, and then you anticipate changing the order with a full order, and it's entered 62 days later, which order are you appealing? What if this second order never shows up?
Right, well, we've had a lot of cases dealing with that type of situation. But what rule are you saying that the doing it that way would contravene?
Well, as you know, once you enter an order, there's nothing in the statutes or nothing in the rules that permits signing.
Right, but I mean, a court can enter a temporary order. A court can enter an order saying we anticipate further action. And certainly in custody cases, it's extraordinarily common.
I agree with you. This is not a temporary order. The court even agrees with me that it's not a temporary order. In a further hearing in July, the court says no one's pretending. In fact, I'll read you what she said.
Right, I understand that, but I'm still trying to identify what rule you're saying it's in contravention of.
It's in contravention of that. The trial court speaks with written orders. You can't insert a written order and then 62 days later change it.
Right.
You can't amend an order that's already been decided. After you dispose of a case, you can't come back to it, especially if it's outside of the 10 days that 52B lays out for you.
52B, okay, so that's the one you're relying upon. Okay.
52B, sorry. Trial court can only modify findings of fact and conclusions of law. And it also, there's a Spoon versus Spoon case, 2014 from Court of Appeals, that says, in addition to modifying findings of fact, trial courts possess the authority to amend their conclusions of law in child custody cases after initially entering the judgment. And I read that to be within that 10-day period.
Was that a rendition or an actual order?
It says amend in the case, in the Spoon versus Spoon case.
Okay.
I mean, but, you know, the issue we have, particularly in child custody cases, is what happens between the rendering of an order, the oral rendering of an order, and, you know, by the time the order gets finally drafted, the parties have agreed to the form of the order, gets back to the trial court. I mean, we often have these gaps in time where it's unclear, you know, the enforceability of the order, and we're dealing with issues of child custody, right? Which sort of, we need some certainty. So
Perfectly
that's,
understand.
isn't that why this sort of memorandum of judgment type practice?
The problem is getting proper judicial review. So when we don't know when the second order is going to be issued, and if I wait, I'm waiting outside my 30-day window. I'm waiting.
We'd have 30 days. Sorry.
You're assuming the window opened.
Is this an interlocutory order, or is it a permanent order that I have to follow? Is it an enforceable order that I can be held in contempt for? Because if it is, then I'm entitled to judicial review of that order, and that's the order. So yes, there's a period in time in
You
which
can be held in contempt of a temporary custody order.
it's a temporary permanent custody order, because this is a hearing dealing with a permanent custody matter, and she's issuing a temporary permanent custody order, and then she enters the permanent custody order 62 days later. So what happens if I want to appeal this order? I'm not entitled to my appeal until after 62 days. What happens if the second order is never entered? What happens if it's entered 6 months later? So, and then the Court of Appeals would tell me, you're outside your 30-day window. So there's a lot of problems here if the Court of Appeals allows this pocket in time. This particular case is only 62 days, but there are other cases that could be longer. It could be, you know.
So are you suggesting that we should somehow prohibit the use of these memorandum of judgment?
I don't think it's following the law, Your Honor. I don't think that you can enter a skeletal order and allow proper judicial review.
Well, even where the trial court has specifically stated in the order that I am doing this because custody needs to be dealt with, the child will be with this person on this date, and attorney, you are to prepare an order and submit it by this date. Even in that situation?
Even in that situation, Your Honor, because the problem is you're introducing issues into judicial review.
You know, in this case, I'm looking at the order, at the memorandum of judgment. It says in the title, formal order pending. And then at the bottom, a formal order, judgment/order reflecting the above terms will be prepared by and submitted no later than 30 days for signature by a judge assigned to hold court in this district.
No later than 30 days, but this was submitted, she entered in 62
Well,
days.
aside from that, though, so you're saying even the use of a temporary, a memorandum of judgment like this with a formal order pending, you're saying is not satisfactory, it's not something that should be allowed?
It's not, because it's an order. The court speaks through orders. It renders the decision and may, you know, and I, what's the case? There's a case that deals with the rendition that I put in my response brief, that trial courts or courts only speak through written orders. And you can't speak through one side of the mouth and say, here's the skeletal order, and then some later time, here's the full order. Okay? You have 10 days. So unless the legislature fixes this issue, I think the Court of Appeals is stuck with what the 52B language is. And that language does not allow the court to just sua sponte amend its own order unless it's inside the 10-day period and unless it conforms with Spoon and 52B.
Well, if the concern is the timely entry of the final formal order, findings of fact, conclusions of law, isn't the remedy mandamus?
No, Your Honor, because
I mean, that's the THT.
That's if they haven't entered the order. If I want the court to act, and I'm assuming by that time I've already passed my 30 days. So which order do I appeal? Do I wait for the final order? If they don't put the final order in, do I put a written mandamus? And then the judge decides, I don't need to because the appeal period has passed and you can't appeal this anyway. So the issue, it gets really murky if you allow a skeletal order to be entered and the 30 days pass. And then I'm only left with the option of a writ of mandamus, and then, you know, the court decides I'm going to keep the skeletal petition, let's say, as an option. There's a lot of problems with allowing this type of custom that doesn't comply with, doesn't allow proper judicial review.
Well, in this case, and certainly we have murky cases, and we have cases where there's a huge gap between orders. This one, as I recall, actually, the order was submitted, and then the attorneys were fighting about it and had to go back in to get the judge to, you know, figure out the correct version.
This particular order, no, Your Honor. This was
not on this one.
This one was submitted, and the court sat on it for a while. I think almost 30 days, or more than 30
But it
days.
wasn't like months or years.
It was like 45 days-ish.
Okay.
Before the trial court entered it. And that's the second issue to that is that I appealed the first order,
Right.
and that removed jurisdiction from the trial court, and she entered it anyway. So the trial court had no jurisdiction to enter that amended order and entered it anyway, because that issue was now in the Court of Appeals. It had to be disposed of and then brought back to trial court before they could enter.
Well, aren't you assuming it's an amended order when the trial court is described as a formal order?
Well, is it a
pending?
superseded order or an amended order? Whatever the language is, it's a second order that supersedes the first order. So you're either amending the first order or you're superseding the first order. Because you have the appeal.
Or you're entering an order that was anticipated by the first order.
Or you're entering, yes. You could say you anticipated, but again, which is it a temporary permanent order or permanent order? So I don't think the rules contemplate entering temporary permanent orders.
Well, our law says a temporary order is one that contemplates further action by the court and sets a date for it.
Then why would we have rules, Your Honor, for 52B that puts in the issue dealing with amending findings of fact and conclusions of law when and the court doesn't take advantage of that?
Well, how did the court amend any findings of fact when there weren't findings of fact here in the memorandum of judgment?
Because what the court did was,
Didn't the court provide findings of
the
fact?
court's own words in July 20th was, no one's pretending it's a temporary custody order. That's just, addressing custody on a temporary basis. The terms are meant to be permanent, but the only thing that's in this memorandum are the nuts and bolts of where the kids are going to go for a short period of time pending the entry of a formal order. And if, like I said, if the Court of Appeals says that's a full order that's appealable, then their word controls. We won't do it like that anymore. But I don't know any other way to do it when circumstances are such that there has to be an arrangement for the kid before an order can be physically done.
And you don't think this is within the inherent power of the court?
No, Your Honor, I don't. I think that you have a lot of problems trying to suss out when your appeal period ends. Are you waiting for the second one, or are you waiting for the first one? So some type of, fix, patch has to be done by the legislature here, but this has to be prohibited until that occurs. This is not the domain to make up rules. This is for the legislature to fix. If they want a temporary fix, like you can enter a skeletal petition, then it needs to have some type of special category that it calls it interlocutory, and it's a statutory period that exists for this interlocutory temporary permanent order. But none of that framework exists right now. It's just you have this order, and the court says, I have this formal order coming, but then we have all these problems of judicial review, whether or not it's an amended order, whether it's a superseded order. I don't think the rules of civil procedure or any case law permits that. Moving on.
Given you're at pretty short on your time, I'll give you a couple extra minutes since we had a lot of questions. But anyway, just wanted to point that out.
Thank you. The springing contempt order, it starts with the December of 22 contempt order when the trial court basically follows the issues stemming out of County of Durham versus Burnett.
Did you appeal that order?
No, that order was not appealed. I was not involved in the case at that point. I was doing something else.
So as I understand it, the basic gist of the springing contempt order argument is that when you have a purge condition, then come back and we'll see if you've met it or not. And if you've not met it, then we'll imprison you for contempt. But the issue is, at that moment, was there an ability to comply, right? At that hearing, there needs to be a new finding of ability to comply at the time.
The springing is if the trial court does not find that there's an ability to pay, absolute ability to pay, which it wasn't done in the contempt order. It has to be like an inventory of financial condition, saying that the plaintiff has a car, purchased a home, has 4 vehicles. It doesn't go into what the type, size, age, value, condition of that property is, whether it can be converted and liquidated. None of that stuff is discussed. And so that is the stuff that has to be discussed in a motion to show cause. That's the ability to pay. What property do you have? What's its equity? Do you own it? Let's see the title, okay? Not he has cars. He hasn't paid.
And actually, I know you're running short on time. Remind me of the posture. Was this a motion for contempt, or was this under a show cause?
No. What happened was, in the contempt order itself, it says you have to appear at my calendar calls and tell me whether or not you paid this $4,200.
How did the contempt arise in the first place? Was it
you
a
didn't
motion
pay the
or
child support.
no? I understand procedurally. Was there a motion for contempt, or was it to appear?
Appellee
order to
filed
show
a
cause?
motion for contempt.
So it was a motion for
There was
contempt.
no show cause
Okay.
order.
Okay.
As I
Got it.
recall.
Thank you. That's all right. Sorry.
There's a motion for contempt,
Got it.
and then the hearing, the court.
So the burden of proof remained on
Yeah.
on
found
the
the
movement.
plaintiff's contempt. And in the order, it says you have to show up at calendar calls and tell me whether or not you paid $4,200. Oh, you didn't? Jail. No hearing about ability to pay, no current inventory, no contemporaneous finding that do you have the ability to pay at this calendar call, or this calendar call, or this calendar call. Just poof, jail. You didn't pay, jail. So that's debtor's prison. That's not contempt. There has to be a willful disregard of the order. In order to be willful, the court has to show that you have money and you're not applying it to the judge, to the child support order. And that didn't happen either.
And like I said, your time, I'll give you an extra 3 minutes for rebuttal.
Okay,
Come back
thank you.
if you want to keep that for rebuttal. Thanks.
started since 2016. I would like to answer the questions that the court has, but happy to spend my time first on the rebuttal to what was just discussed by Mr. Browner based upon the court's questions. First, to start with, and I'll go in order as Your Honor brought them up, the motion to continue. I think it's really important to point out to this court, as the record indicates, that prior to the motion to continue being filed by Mr. Browner, Mr. Roybal had filed a motion to stay pro se right before that, and he subsequently dismissed it. And I would stand here today and concede that at least the face of that motion for stay complied with the or the Service Member Relief Requirement Acts. So not only has he proven under the record on appeal itself that he knows as a pro se individual how to file that, frankly, he filed it from jail. He was currently in prison at the time for his failure to pay child support, as the record indicates, during the time period in which he filed that motion to stay. To go back to Judge Stroud's question in terms of the authority, if the court treats this as a motion to continue, so the subsequent one, which we're here for today, that he filed in March of 2023, you have to apply General Statutes 1A-1, Rule 40. If you take that at its face, even though it's called a motion to continue, as a motion for stay, then you have to apply the Service Members Relief Act. If you review...
He filed it as an SCRA pleading. I mean, he refers to the SCRA in it, right?
No, actually, he does not. The motion in order to continue that he filed, that was filed on March 27th of 2023, Your Honor, he does reference military service, but he does not reference that statute anywhere therein. And if you look at the exhibit that was actually attached to that, the communication that Mr. Browner would like the court to accept in liberal construction compared to what also he had filed previously, I believe in that February motion, it actually says you need to come in before the BA to make up. So it's not actually, from our perspective, it wasn't military training he had to come in.
Well,
he had to
it
come
says,
in early.
he said, I believe in there, the basis for the motion was mandatory military duty dates extended for pending deployment 9/23. Original date was 3/30/23, time was moved, and had the email from the commander. So I'm just trying to figure out here, under the SCRA, which says that it requires a letter or other communication setting forth the facts that will affect the ability to appear, and that they are not available at the time.
Yes, Your Honor.
And the argument before the trial court was actually that he was not considered on active military duty, and that the email didn't list all of the training. So, but I don't, as I read the orders and the email, it would appear that he is, for purposes under the SCRA, on duty that would be covered by the SCRA. So that's where I'm trying to figure that out.
Well, and with all due respect, Judge Kate was also trying to figure it out. If you read the transcript, which I'm sure Your Honor has, from the March 28th as well as the March 29th, she denied it on March 28th. She referenced the motion to continue as is and had actually asked for authority to be brought by myself, even though I represented the defendant in the matter surrounding the Service Members Relief Act, because she was concerned it could be treated as a motion for stay versus a motion to continue. She didn't directly state that, but if you infer what it is that she was requesting and what she then sought out, she did. So then when we came to court on March 29th, that is when the additional information surrounding the Service Members Relief Act was provided to her, along with a copy of the SCRA affidavit to show that it was not listed as active military duty. Because I personally, had Mr. Roybal followed the statutory requirements, then it would have been clear to the court whether he was considered on active military duty and those requirements were met. Instead, all she received was this one-page email.
Right.
This one-page email that specifically states you need to come in before the training begins. It does not state whether this commander was at all aware of the fact that this man had a court appearance that day. There's nothing in there to that effect. It doesn't state when he could be available again. It is our position that that is the reason why the Service Members Relief Act is written the way that it is so that it requires the service member to fully disclose not only to the military, but to the court, the status of each other. And he didn't do that in this case, but yet he knew how to, because he did it properly when he filed his original motion to stay, that he subsequently dismissed.
But of course, he had sent the email, as soon as he got it, he sent you the email regarding the date, I think on the, let's see, 27th.
Yes, Your Honor. He forwarded the email according to his pleading filed by Mr. Browner. His claim that he had sent that to me on Friday. He absolutely sent that to me on Friday.
In the
after
record
we closed.
supplement.
I did not receive it till Monday morning, immediately responded. He then filed his motion. And this was for a case that had been, frankly, had been outstanding since 2022 because of, it wasn't a matter of nobody chose to calendar it.
Yeah.
We were still in court on the contempt actions that had been going on for over a year and a half.
Sure. Y'all had a lot of stuff going on.
Yes, ma'am. The individuals in this case have appeared on over 35 times.
Yeah. And I was looking at the status report for the Service Member Civil Relief Act that you'd prepared, and I was just reading the sort of the fine print over on the second page.
Yes, ma'am.
And it points out that coverage is broader in some cases. In other words, this might not cover everything. Many times orders are amended to extend periods. People, should check to make sure the orders are based on the amended and include, it basically says, there's a lot of stuff that might not be included in this report. And obviously a last minute change to something like this would be something that probably wouldn't make it there. So I'm just, it doesn't seem to me that the status report necessarily answers a whole lot in this particular situation.
It doesn't, Your Honor, and even the memorandum, it's actually it's page 118 of the record on appeal. It does state mandatory battle assembly dates, but those dates obviously fluctuate because we've seen them change in this case over and over. Mr. Roybal did participate in the timing in which the March 29th date was actually set, because the transcript that is in the record explicitly goes through Judge Cave trying to accommodate all of the potential times that Mr. Roybal was going to be gone, and this would have been before he was deployed. He was not actually deployed until October of 2023.
And when you were in court on the 28th, actually, in the discussion of that, actually Ms. Rowley said he's already gone. So
To Virginia Beach.
she was aware that he was already.
To Virginia Beach, and there had been prior proceedings within this case itself that I believe was part of the record the last time we were here, where he participated via WebEx. There was no request by Mr. Roybal to do anything else other than this motion to continue, which I believe Judge Cave went above and beyond to try to confirm whether she was following the Service Members Relief Act, because that has come up so many times in this case, and it doesn't come up often in front of our trial court judges. And frankly, with all due respect, I have the utmost respect for our military, and it is very hard for me to stand up here and act as if I don't, because that's not my intent. But at some point in time, these children and my client also have to be taken into account. The service members' families have to be taken into account. And I believe that that's a tough weight, right, to be able to determine how to do that. And I believe Judge Cade intended and tried to do that. And she's been in this case since 2016. She has a long-standing history with the parties in this case, including during that time when Mr. Roybal had been previously deployed. So it's our position that first, that we believe that it's treated as a motion to continue, therefore she has discretion whether she is able to agree on it. But if the court were to say the Service Member Relief Act is what applies, he didn't meet the statutory requirements of that. And the case law that Mr. Browner would like for this court to employ in order to say she should have granted it is very different, because every single case they found it was a properly filed motion for stay. And they go through the elements that are required in order for it to be proper, and how the service members in those particular cases had in fact complied. And the one case that he referenced here today, that with the judicial, the case where unfortunately that judge had been admonished, is very distinguishable from our case at hand. That that service member had counsel, I think in fact had two, had filed the proper motions, had filed various pleadings, had confirmed the fact that he was deployed. There was no question as to his status. In this case, there was a question, and Judge Cade exercised her discretion when determining whether she was going to grant that or not.
I had a question. I saw in,
Yes,
in
ma'am.
one of the orders, there were actually some findings noting that his request was not verified, and noting the commanding officer had not ever appeared or testified. Was there any suggestion that either of those is required? Because I can't
There
find
was
that.
not a suggestion that there was a requirement, but there had been significant concerns as based on, I believe, several of the transcripts this court has, as to Mr. Royball's credibility and what then would have been disclosed. And frankly, this commanding officer's credibility, because the commanding officer had provided that he was going to instruct that garnishment would take place, that he was going to work to ensure that my client received the money that was owed, not under the, just under the contempt action, but frankly, for child support obligation, which was never done. So there was a question, and I fully believe that is why Judge Cave made the specific findings that she did surrounding the verification, because I believe in the transcript, it would either be on the 28th or the 29th, she made a reference to that she has never heard of, spoken to, or had anything verified from this officer. But the statute itself does not require it. And most of, again, pure speculation on my part, but I don't think it's necessarily anticipated that that would be required, because with military orders, they look so official, right? And that's what's generally going to go in front of our judges. But in this case, it was an email. It was an email on the heels of him coming to court on a motion to modify that had been pending, where my client was seeking sole legal and primary physical custody of the kids. Any further questions in terms of the motion?
Well, let me circle back to
Yes, sir.
to Judge Stroud's initial question, which is, what then is the standard of review in this case on that issue? Is it purely discretionary, or is it, is it sort of a matter of law based on sort of factual findings, right? If there's compliance with each of the elements of the statute, was a stay
Right.
sort of mandated?
And it's our position that since he didn't meet the statutory requirements, it's treated as a motion to compel, and therefore the standard on the field would be abuse of discretion. And that Judge Cave did not abuse that discretion, and therefore there is not an error in the fact that she denied that motion, that she frankly considered for 2 days.
Well, and then, later on, there is this more sort of like fulsome order where it's staying civil, commitment for the civil contempt, where we have, fairly extensive findings of fact and conclusions of law, which we don't have here. Would that have been, would additional findings have been helpful on the initial, in March, rather than just, checking the box saying, motion continued denied?
So I believe our trial courts are so overbooked right now. She made those findings when she gave her oration, Your Honor, on March 29th, but those are not cited until that May order, which is very similar to even the June order that she submitted in terms of the order to stay that was issued ultimately in this case. She referenced something back in April as far as him not presenting evidence at that April 25th, 2023 hearing, when he had in fact had to come in order to submit his purge payment. I think that's just more of a, she gave her oration as to the reasons why she had to proceed and go forward that day. In fact, you'll notice in the transcript, we had to come back. So we started that morning, she had to take multiple cases in between us, and then we came back that afternoon to have the ultimate hearing on the motion to modify. And on March 28th, when she heard from us, we were scheduled to be in front of her on March 28th, because that was a day that Mr. Royball was supposed to appear in order to make a purge payment. Now, in that instance, she did continue that out to be able to talk about on March 29th. But I do believe that that could potentially have helped as far as what we're requesting of this court, or what Mr. Royball is, but I don't think that it's required. I think she ultimately did that. Also, just to clarify, Mr. Royball was not incarcerated in January. He was incarcerated in February. I just want to make sure that the record is clear on that. And when we get to the March 29th order and the issues surrounding whether this MOJ, the implications, let me just say it that way, the implications of this MOJ. I believe we can't find case law on it when someone's ever taken it to the Court of Appeals. We do this all the time. Because again, as service member have rights, so do the parties in our actions, and so do these kids. And if you read the order that ultimately resulted from that hearing with the very detailed findings of fact, it's 12 pages, it's a 12-page order. We cannot prepare a 12-page order at 4:30 in the afternoon of trial. Half the time we are going past 5 to just wrap up the trial itself. The order was in fact submitted, and Mr. Roybal was copied on it. At that time, Mr. Roybal was not represented. So Judge Stroud, when you were asking if the attorneys had gone back and forth, Mr. Browner is absolutely correct. That didn't happen. I submitted the order within the 30 days. There's no question to that by anybody that's been involved. Judge Cave received it, and then we ultimately got it back after that 30-day deadline, which also is not uncommon. Judges have to take the time to be, and we want them to, right? We want them to take the time to be able to review those findings of fact, reflect on the evidence that was presented, and ensure that the order is written, because I'm typing it, I was directed to, but that it's based on her findings. If you read her oration on March 29th, we spent a good chunk of time of her giving us her findings of fact and fleshing out what it is that she was going to order as it related to physical custody. This particular case not only would it have impacted the best interest of the kids from where am I going to lay my head at night, it also impacted their mental health. Without entering that MOJ, the children would have continued to not receive the services that, as the subsequent order clearly indicates, the formal order, I should say, that formal order that they needed, that they were not being able to get because of Mr. Roybal's failure to respond under joint legal custody. So Judge Cave submitted, and I appreciate Judge Stroud and Judge Zachary, you pointing out the language within that judgment. In fact, she scratches out judgment. It's an order. This is a 2-page AOC form that normally there's a back to it. And we use these if we come up with a consent. The record will reflect we've entered them multiple times in this case. And that consent order that we sign in court, because we don't have time to flesh out all the formal specifics of it, that we then subsequently submit a formal order. Judges also routinely and regularly, and there is no rule that I can find that says they can't, in their discretion, enter these orders at the end of a permanent trial. Because it does have implications if the court actually treated this as temporary, which is in fact why I believe, speculation I understand, Judge Cave did what she did when she said, I'm not doing a temporary order in this case. It had been pending since 2022. There had been multiple modification orders that had been entered prior. If she would have done it as temporary, she's not bound by that. And then we have to go back and try the whole thing all over again because of the way North Carolina case law is written. So she entered this clearly stating the formal order was pending, stated that findings of fact and conclusions of law were forthcoming, and that it would be in that order that she was requiring me to provide within that 30 days, which we did. I disagree with Mr. Browner in terms of Rule 52 and its application to this case. I do not think that Judge Cave violated these rules at all. I believe that this is a procedure that has been put in place in order to cover the best interest of our children and ensuring that family court can be run properly. Because if we are going to take the position that at the end of a permanent hearing, sometimes that takes a week, if not sometimes that extends over a year because of how many times we have to go back to be able to finish it, that you can't enter one of these orders just at the end of that day, you have to go grab your laptop, type everything out, and have this done. We would be requiring our clerks and our judges to stay there until late into the evenings to be able to get that done. It's just impossible in most cases. On top of that, if you read, and it's not, Mr. Browner's argument seems to be that it causes issues. I'm not sure the issue that it actually caused in this case. If he was concerned that not filing a notice of appeal would have an impact to that order, which I don't necessarily agree with, the reality is he did it. He filed a notice of appeal, just in case. He then subsequently timely filed a notice of appeal to the formal order. I think his argument would be stronger if some of this language was not within this order to where this court could not interpret what the intent of Judge Cave is, which goes back to my argument about this email. It's very hard to interpret what that meant. But there is no rule and no case law, Spoon is, in my opinion, not applicable to this case, surrounding this being an error on the part of Judge Cave, which would ensure that the order, the MOJ she said within her transcript on when Mr. Browner had filed at the trial court level that I didn't treat this as temporary. This was my order.
Yeah, I think, and maybe the words temporary and permanent are kind of deceptive here, because, I mean, we've got plenty of cases in custody situations in particular, that say, you know, the trial court's characterization of the order as permanent or temporary is not controlling. What we look at is the substance of the order. Is there a date set for specific action? So, for example, not uncommon to have a hearing, and let's say the court's decided that we need a psychological or psychiatric evaluation of somebody, and we do an order saying, okay, here's our custody situation right now, and we're going to come back in October for a hearing after this person has had an evaluation, and then we're going to, you know, look at how things are going to proceed from there. I mean, happens all the time. And if, in fact, the court has set a clear reconvening date for whatever purpose, we treat that as a temporary order.
Yes, ma'am.
Even though a lot of the provisions of the order might be what we would call permanent. They've already, the court's kind of decided how they're going to deal with certain things.
Yes, ma'am.
I mean, it seems to me it sort of falls into that neighborhood, maybe.
I don't necessarily disagree, Your Honor. I think that the reason that this is difficult is we can't hand you something that says, here's the rule she violated, because that doesn't exist. But to counter to that, here's the rule that allows her to do it. I think it goes back to the inherent powers of the court. She has the ability to be able to do that. And even if you go to the child support, or excuse me, the child custody statute itself, that statute actually gives the court the authority upon having jurisdiction to enter temporary orders. I mean, we do that all the time, but I think we get lost in the just definition of the layperson temporary versus permanent. But in this case, it's very clear to me, she gave a permanent ruling. She then did this MOJ, as we call them, which really it's just a handwritten order, to say this is what I'm doing, and this formal order that will include these terms. These terms aren't modified. That include these terms are in fact going to be part of that.
Do you have any idea how long we've been using memoranda of judgment in this case? I mean, not in just in the state.
So, Your Honor, I don't know the answer to that, but I know the last time that this form was updated, according to what I'm looking at in the footer, was in 1997. It has to have been before then.
I started practicing in the 80s, and I don't remember ever not having
I don't either.
memorandums of judgment.
And I have seen them in, frankly, court files dating back to prior to 1997. But, Your Honor, I don't know when these forms were actually created. But I do know, according to the record, this was at least last done in 1997.
And they're used in more than just domestic cases,
Yes,
am I
ma'am.
correct?
Sure.
Yes, ma'am. It's an AOC form. It's AOC CV 220. And yes, I see them used in all different courtrooms. In fact, when you go into the courtrooms, you see the little slot for you to be able to go and get them. Even with e-filing now, you can still go get them. We just got to now scan them in. Yes, ma'am.
And there's utility to them in that
Absolutely.
they provide an enforcement mechanism in the interim before a formal order is entered, in case there is a question as to whether a parent is properly in custody of the children. Right? You've got
Absolutely.
that piece of paper and not just, well, the judge said.
And absolutely, and to your point, Judge Hanson, still, I mean, it's still enforceable. As you had said, even if it was considered a temporary order, you can be held in contempt for temporary orders. But also in this case, it wasn't just about the physical custody. There's a reason that legal custody was specifically referenced in this. My client could not have gone to any of the providers to say, hey, you can see my child without this. She would have had to wait until Judge Cave was able to get the formal order back, because it's not just about the attorneys being able to have the time to prepare them. We do them in a timely fashion. She has to have the ability to be able to go through it while she's also hearing other cases and running her district to be able to get it entered. Any other questions that I can help for on this issue? Okay. In terms of the springing contempt order, and I apologize, I don't remember which of the three pointed this out, but you are absolutely correct. That order for contempt that was entered in December of 2022 was never appealed. He had counsel, Mr. Roybal had counsel, Mr. Oswald at the time, as referenced in the record. What is also referenced in the record, Mr. Browner was involved in the case in January because he was at the calendar call in January saying he was listening in on the case. request, do a motion for order to show cause, in all honesty, it costs our clients more money in that district to do it. And as you'll see, that hearing took place over, I believe, almost a year and a half. And I would disagree, even if this were proper to be in front of the court, that the findings of fact were not sufficient to support his willingness to pay. There is detailed findings of fact.
But I guess the question would be, at the time of the contempt order, though, so the initial order sets out, okay, he's going to pay $4,600 on this date, and then he's going to pay another $4,600 on this date, et cetera. The problem is, I think, that he's raising is the fact that on the date when he shows up to pay, if someone is going to be incarcerated for civil contempt, there has to be an ability to pay.
Yes, ma'am.
You have to hold the keys to the courthouse.
Yes, ma'am.
On that date. So the fact that you were able 1 month ago or 2 months ago or 6 months ago is interesting, but I don't see in the order any provision for him to be able to come in and present anything about his ability to pay on that date. It just says you come and pay. If you don't pay, you're going to jail.
And actually, I disagree.
Okay.
The fact that she says you come in to these calendar call dates, she explicitly states the date he has to appear to confirm the purge payments are made. And every time under the transcripts that this court has that he appeared, that he had notice to, she puts him under oath and she questions him. It is not her burden to provide evidence of his ability to pay. And frankly, I somewhat equate it to, although I know it's a little bit different, in terms of if someone has already been in prison, right? In this case, she gave him an active sentence that she subsequently suspended to be able to give him time to pay. And in, I think it was the January transcript she references to Mr. Oswald, in my mind, I treat this as it's just a continuation of the compliance of that order. That is a statement that she made. But actually what she does is she requires him to come, he shows up, she does her calendar call, she calls her case at the end of it, she asks him what he has to pay, and then according to the testimony, because even one of the civil commitment orders, Your Honor, she modified what the purge payment would make, because he presented evidence that I have $3,000 today, but I don't have the additional $1,600 and I can't pay that. She said, okay, pay the $3,000, which he actually didn't have that day. He said he would do it within 48 hours, and I just had to confirm. And then therefore, that purge got added onto his next purge payment where he was supposed to appear surrounding his payment on that date. He had the ability at every appearance, and again, I will reiterate, he has been in court over 34 times, to be able to put on evidence surrounding his ability to pay, and he didn't. But the case that Mr. Browner is relying on, that he reports is analogous, I guess, to our case, is the Tigani, T-I-G-A-N-I case. That case is clearly distinguishable from the case at hand here. In that particular case, the defendant was held in contempt, required to pay, I believe it was $28,000 by a certain date. At the time that he was required to pay, he failed to pay. There was nothing in there about showing up for a purge payment, active sentence being suspended or anything of that nature. So they filed another motion for contempt and request for order to show cause. There was a question as to what was actually said when they came back on that day. And then instead of taking evidence on that day, on the underlying motion for contempt request for order to show cause, there was a proffer of evidence by, I believe, plaintiff's counsel. Defendant did not appear, defendant did not have counsel, and there was nothing else. There was a proffer, and even that proffer only included bank statements or proffering of evidence surrounding a period prior to the time that even amount was due. That's not the case at hand here. What's at hand here is whether, because there wasn't even an appeal of the commitment orders that were entered prior to this. The April one was not the first one. It wasn't until this one in April, which frankly right now has become moot because there is a stay in place, although he's back. That is clearly distinguishable from this particular case. But also, Your Honor, while Mr. Browner did request the transcript from the April 25th, 2023 hearing, it's not in the transcripts that this court has. It's not in the transcripts that were provided to me, but it is referenced in the June 2023 order. That was the date that the commitment order was actually entered,
What date was it? Because-
April 25th of 2023.
Okay.
That was the date that that commitment order was issued for him to then be incarcerated, to which he was incarcerated. But there is a finding in Judge Cave's order that is in the record, since y'all don't have the transcript from April of 2023, in the order saying civil contempt that she issued on June 20th, 2023, that I believe is in page 228 of your record on appeal, where Mr. Roybal failed to provide evidence on April 25th. That can be inferred that he was there, that he was given the opportunity, and he chose not to. And that is a specific finding of fact in the June 20th, 2023 order.
And you're over time, but we asked a lot of questions of you too, so I'll give you a couple minutes to conclude if you need it.
I'm sorry?
I'll give you a couple minutes to conclude if you need it.
Your Honor, I'm just asking, I appreciate the court's time today. As Mr. Browner said, this is our second time here on this case. And I trust the court, and if there's any other questions that end up coming about based upon the time that he has left, I'm certainly happy to answer any questions. But I believe it's abundantly clear, not only based upon the arguments today, but the law that's been presented to you, the transcripts that have been presented in the record on appeal, that the trial court did not commit error. Thank you.
Okay, thank you. All right, and I said 3 minutes, I think I said.
Yes, Your Honor.
Yes.
I want to remind the opposing counsel is saying that it's for the children, it's important that the children have to know what's going on. This is the first time on, it's not an emergency. All right, this is not an emergency motion. There's no physical harm going on. So this is a motion that can be decided in due time. There's no reason that we have to have a skeletal and then a permanent. Opposing counsel references the stay. That's a different statute that we're talking about. That was a stay under 3934, which is the stay or vacation of execution of judgment, attachment, and garnishment. And the one that we're talking about for motion to continue is stay of proceedings when service member has notice. So he's in jail, and I'm trying to get a stay from the commitment order, not a stay from a hearing while he's in military service. She says, opposing counsel says that no state allows without a letter from the commander. You have, in my response, Texas says you're allowed to have a stay without a commander. So does Nevada, Washington, Pennsylvania, Georgia. You know, our state hasn't ruled on it yet. That's literally how different states have liberally construed this statute. That the spirit of the statute is you have military service. You don't have to have a letter from your commander. You don't have to have a strict compliance with the statute. There was a discussion of verification. Judge Cave was not very tolerant. She was tolerant in the beginning, in the May period and June period, but in July, when I came for another hearing, she was not tolerant of, and I referenced that, this statute, saying it's a letter of communication that has nothing, no affidavit, no verification requirement, and opposing counsel was pushing the idea that in order to be evidence in a case like this, you need to have some type of, sworn testimony, affidavit, verification. And I don't think that's part of any of that. The statute's very clear that it's a communication, a note, a verbal, just anything that says I have military service blocking me, and here are the dates. As long as you follow the statute, you're in compliance. Thank you, Your Honor.
All right, thank you very much for your arguments. And we will proceed to our next case.
Thank you, Your Honor.
Thank you,
Did
Your
y'all
Honor.
want to take a break or anything? You should proceed. Yeah. Okay. You good?
I'm fine.
Okay. All right. Inscoe v. Ishee.
Oh, I got you.
apparently our flags were in a bad place for the cameras, so technical correction there. We don't normally move flags during court, but just fixing it, make sure everything works right. And for time for rebuttal?
5 minutes.
5 minutes, okay. We'll get our clock set up for that. And we'll proceed.
May it please the court. My name is Orlando Rodriguez from the North Carolina Department of Justice on behalf of the appellant respondent. I'm joined here at council table with my co-counsel, John Milholland. We've already reserved 5 minutes for rebuttal. Your Honors, this case is about discretion. It's about the discretion of the North Carolina Department of Adult Correction to consider factors beyond what appears in one's birth certificate when it makes determinations about where to house a given individual. The trial court in this case erred when it issued the writ of mandamus, directing the department to transfer the petitioner, and this court should reverse that writ of mandamus for two primary reasons. First, the trial court's statutory interpretation, which is reviewed by this court de novo, improperly strips the North Carolina Department of Adult Correction of its ability to consider a multitude of factors that go beyond what appears in one's birth certificate when deciding what an appropriate housing assignment should be for a given individual. Now, the department recognizes that there are unique challenges associated with housing gender-diverse individuals, particularly in the carceral setting. That is why the department has instituted a policy, a committee that is dedicated to reviewing certain types of requests by that population. That committee is the Division Transgender Accommodation Review Committee, otherwise known as the DTARC. That DTARC committee is comprised of high-level custody and operational professionals in the department, as well as chief clinical officers from behavioral health, psychiatry, and medical.
Why isn't the sex listed on the amended birth certificate determinative?
Because if the statute is interpreted such that the sex on the birth certificate becomes determinative, then the department would be completely unallowed to, not permitted to consider any other factors. And there are plenty of sources in our law that provide the discretion for the department to use that consideration of other factors beyond what appears in a birth certificate when it's making these types of decisions.
What other factors would you consider?
Well, the statutes, Your Honor, speak to this. So 148-36, which is in the chapter that governs the operation of the state prison system, it provides that the department has broad discretion to designate the appropriate facility for a given person based on custodial and correctional considerations. That is a broad phrase. There's no limitation there in that statute. And that is in keeping with copious amounts of cases, federal and state cases, that recognize a correctional system's discretion, the discretion that we must afford to prison officials to deal with a dynamic and often evolving situation inside of prisons. So the department has to be able to maintain its ability to consider a broad set of factors and should not be handcuffed by a single designation. That is one piece of information that is certainly part of the consideration, but it should not be the sole bit of information that the department is permitted to rely upon. Getting back to, before we get into the other reasons why the trial court erred here, some table setting might be helpful. I mentioned at the top that there were two reasons that this court should reverse. The first is that the trial court's interpretation here strips the department improperly of its ability to consider a host of factors. The second reason is that the writ of mandamus here, the elements are not supported on this record. Before we turn to those, it's helpful to kind of zoom out, I believe. So this is a supplemental petition for writ of mandamus filed in August of 23. The trial court then ordered the department to conduct a review to decide on the petitioner's request for a transfer. That review was conducted by the DTARC, which I mentioned is a multidisciplinary panel that decides these sorts of requests on a case-by-case basis. Now, the DTARC's decision is a holistic review of all available information. This includes health information, criminal history, prison records of the individual, whether the person has any history of sexually violent or assaultive behavior, how the person is participating in programming, that would be vocational or educational programming, and much more. Now, through this review, the department's goal and its aim is to balance both the health and welfare and the needs of the requester with those of the population as a whole, the prison population as a whole, as well as the operational and security needs of the facilities. And in this case, the DTARC determined that a transfer would not be appropriate for the petitioner because of security and operational considerations and concerns. Those concerns, namely, were the risk posed to the petitioner's safety and the safety of those that are housed at the facility to which she requested to be transferred. Now, this concern for safety was driven by the petitioner's history of sexual assault. And these security concerns were compounded by the DTARC's concerns around the petitioner's mental health, particularly a cluster of personality disorders that can impact one's judgment and decision-making, as well as other issues that the DTARC identified in its comprehensive review of the petitioner's health record.
So, related to the safety concerns, presumably there are inmates in prison, in a men's prison, that have committed sexual assault on men, and the same in female prisons. So, I mean, are there standards, protections, policies, regulations in place to cover those situations?
Yes, Your Honor. The Department of Adult Correction has a host of policies and tools at its disposal to both weigh risks to individual prisoners that they may face because of whatever crime they committed that found them incarcerated, and risks that they may pose to other individuals. And this actually gets at the primary reason that we appealed this writ of mandamus, is that this ruling, if it stands, limits the department's discretion to make case-by-case housing determinations and to make those determinations based on a wide swath of considerations, factors that the department deems relevant in making those considerations. Without the ability to make those, to consider those other factors, the department would be limited to solely looking at what appears on one's birth certificate. And there are many types of different scenarios that we could posit that would create concern. And the department would not be able to address those concerns because it would be limited to solely looking at that one piece of information when making these housing considerations.
But under Judge Shirley's order, which simply requires housing in a female facility, does that limit the department's otherwise discretion to put in place an individualized protections or discipline housing within that facility?
Yes, it does, Your Honor, because the order, the basis of the order, it relies on two things. One, an interpretation of the term quarter to require the housing in a wholly distinct facility. That's one error. And then secondly, to Judge Zachary's question earlier, it takes and treats as dispositive a vital record statute that refers to the sex designated on an amended birth certificate. When you put those two things together, the effect of Judge Shirley's order is to eliminate the department's ability to weigh requests like these, that would be requests for cross-gender facility transfers, to weigh them based on anything other than what appears in the birth certificate. So this would tie the department's hands moving forward in regard to how it determines to best house a given individual. And that is an improper stripping of the department's discretion, and that's why that's the primary reason why this court should reverse the writ of mandamus. And so to turn to the statute at issue 148-44, it's a single sentence statute. Provides that the department shall provide quarters for female prisoners separate from those for male prisoners. And Judge Shirley's order, or his writ of mandamus, he interpreted that as a mandatory requirement to maintain separate living and working facilities for men and women. The trial court further found that the birth certificate was, as amended to indicate female, that was fully dispositive of what type of facility the petitioner should be housed in. This brings us to the primary reason why this court...
Well, I think what Judge Shirley says is it's prima facie. What his order says is it's prima facie evidence, and I don't see any evidence to rebut that from the state.
Yes, Your Honor. Judge Shirley's findings of fact and conclusions of law indicate that. And our point on appeal here, and I think what we tried to argue to Judge Shirley, was that the sex as indicated on one's birth certificate cannot be and should not be the only piece of information that's considered. We don't have to rebut that in order to prevail on our position that the department should retain its discretion to consider factors beyond what appears in one's birth certificate. The department's not challenging the designation on Ms. Inscoe's birth certificate. The department is not challenging the effect of how one can go about amending their birth certificate. That's not at issue here. What is at issue, and what we are challenging, is the impact that an amended designation on one's birth certificate has, or our position is shouldn't have, on the ability for the department to consider other factors.
But I think the prima facie piece is, nothing else appearing. If that was the only piece of evidence
As to one's sex.
as to one's
sex.
gender, that would control.
But the statute does not speak to at all, the vital record statute does not speak to at all what impact that designation and that prima facie evidence, even if we assumed it was conclusive evidence. If the statute said the designation on the birth certificate is conclusive evidence as to one person's sex, doesn't answer our question. And our question is whether this writ of mandamus violates and strips improperly the department's discretion to consider all factors when making housing determinations. And the statute's actually, 148-44, it does provide a requirement on the department to maintain separate quarters. It does not require the department to house individuals in wholly separate facilities. You couple 148-44 with 148-36, which is a statute I referenced at the top, that provides that the department has broad discretion to determine the appropriate facility based on custodial and correctional considerations. And what we have is a broad grant of discretion to the department to house individuals based in appropriate facilities based on custodial and correctional considerations, so long as they are quartered by sex. And that's what happens here with Ms. Inscoe. She is housed in a male facility, but is quartered separate from the males that are housed at that facility. Judge Shirley's order, if it's not reversed, would eliminate the ability for the department to consider anything besides what appears in the birth certificate. And this discretion of prison officials to be able to consider a multitude of factors that may arise in a given case, it's important because prison officials have to account for lots of different factors: safety, security factors, operational factors, medical capabilities, programming needs. If we're limited to solely looking at what a vital record statute indicates as conclusive or prima facie evidence of a person's sex, the department's not in the business of determining what a person's sex is. We can assume the sex is as indicated on the birth certificate, and the department still should be able to determine what an appropriate housing scenario should be for that given individual, so long as they're quartered separately from folks of the other sex. And that's what's happening here. Now, the interpretation here of the trial court's order, the interpretation of the statute by the trial court in the writ of mandamus, we've already touched on how it is improper because it takes and treats as dispositive the vital record statute, 130A-93. That statute, Judge Hampson doesn't speak to what impact it should have on broader considerations. It's a vital record statute. It stands on its own. It states what it states, that is, that what appears is prima facie evidence. We didn't present evidence to the contrary because it's not necessary for our position to prevail, which is we would like to preserve the ability for the Department of Adult Correction to consider factors beyond what appears in a birth certificate. So we treat that as a given. The third reason why, the third sort of sub-argument why the trial court's writ of mandamus here is error is its interpretation of quarter. So the statute does not define quarters. That's in order of operations. That's the first thing we look at in statutory construction, rules of construction, is we look to see if the statute defines the phrase at issue. Chapter 148 does not define quarters. So the next level in the order of operations is plain meaning as guided perhaps by a dictionary. So we point out in our brief, as does opposing counsel, that quarter means lodging and shelter, to provide with lodging and shelter. The record here shows that the petitioner is provided with separate shelter and lodging. She resides in a single cell environment that she can close to the outside environment and not let other folks in while she sleeps and while she uses the restroom, and has private access to showers. We look for cases that discussed in some form or fashion what quarters means in different contexts. We were only able to locate one case out of the Second Circuit It did involve prisons, but not in this kind of scenario. It involved prisons and a National Guard, some National Guard troops and some striking workers. The takeaway from that case, however, I think is relevant here. The takeaway there was that the Second Circuit actually interpreted quarter to mean a residential room within a facility. And that is the approach that the department is taking here. That quarter does not mean, in the text of the statute or in the plain meaning of the statute, does not require housing in a wholly separate facility. It is sufficient if there are rooms within a particular facility. And this idea, this conception of quarters within facilities is supported actually by an older statute, or older version of 148-44. And that older version actually required the department to maintain separate quarters for male and female prisoners, but also to have separate facilities for juvenile offenders. And so this is an indication that General Assembly was not treating these two phrases, quarter and facilities, as synonymous.
Is it relevant that this concept of quartering, not just in this statute, but it seems primarily the way that term is kind of used within the act as a whole, is within the concept of sort of labor, right? And even the statutes dealing with work release, right, have provisions for quartering, and so is that relevant to the analysis at all, that it's sort of focused on sort of prison labor?
I think it could be in the right context, Your Honor, if there are other statutes that specifically reference quarter in terms of making sure that individuals are wholly isolated and separate from.
Well, it comes up in like some of the work release set, making sure that there are provisions for quartering. I mean, as well as the work, I guess.
Right. And so what I don't know, Your Honor, is whether the quartering reference in those statutes or provisions would apply to the work being performed or sleeping arrangements after the work day is concluded. If it's referring to the latter, sleeping arrangements after the work day is concluded, that's what we're talking about here, where you can have separate quarters for individuals even though they commingle. Just like we referenced in our brief that the juvenile detention centers, they're co-ed. The girls and boy offenders, they mix in common spaces, but they reside in separate rooms and they're quartered separately for purposes of using the restroom and sleeping at night. And there's nothing that is prohibiting that in the statutes. There's no sort of conceptual thing against that. Now, the petitioner's arguments to the contrary, she makes several of them, but they're not particularly persuasive. The petitioner's first argument is that the department does not have discretion in making any housing determinations with respect to how prisoners are quartered. This argument's flawed for the reasons that we discussed. It overlooks and kind of muddies the combination of 148-36 and 148-44. You can read those two statutes together to provide that the department has discretion to consider a host of factors when making an appropriate housing determination, and that those host of factors are subsumed in the correctional and custodial considerations. And that has to mean more than just what's on one's birth certificate. And then as long as male prisoners and female prisoners are quartered separately, those two statutes can be read together and can operate in harmony. The petitioner also argues that the older laws that are contained in her brief, so that date back to the 1700s, that those older laws actually show that the General Assembly has intended conclusively to require the separation of male and female offenders in separate facilities. But if you read those statutes closely, or just read them in general, they do not provide that. They actually talk about separate rooms and apartments and make no mention of separate facilities. So those statutes do not support the assertion that it is this long-held historical statutory truth that the General Assembly has always required separate facilities for male and female offenders. Petitioner's second argument, that the trial court correctly ruled that a cell inside of a prison does not constitute separate quartering. The petitioner here makes a dictionary-based argument similar to what we put in our brief. She cites a definition of quarter as, quote, accommodations and lodging. But then petitioner goes one step further to just simply assert that accommodations and lodging include common spaces. But there's no reference to any source material to support that assertion. It's just the next logical step that the petitioner makes in her argument without providing any textual support for that. She makes a similar argument about in correctional spaces, quartering has to necessarily mean more than just, has to include common spaces. But again, there's no textual support for that either in the dictionary definition or any other sort of authority. And this same second argument of the petitioner relies on the same flawed analysis of the older statutes. The third argument the petitioner makes is similar to some of the questioning that I've already received, which is that the designation on the amended birth certificate is fully dispositive, no more questions need to be asked. That is at the heart of the stripping of discretion that we're arguing here. If that is the law, then the department and the DTARC, they don't have any work to do. They don't have any difficult tasks to consider when they have to review and make decisions about what is admittedly a very difficult and unique set of circumstances. They can't consider anything else besides what appears on one's birth certificate.
So how do we square those two statutes, though? Because on one hand, you have the statute you rely on, which specifically calls for individualized determinations as it relates to inmates, but then we also have this other statute that clearly, in and of itself, makes a distinction between male and female prisoners. So it's, at some level, it seems like there has to, I mean, whatever, it's the statute, right? So there has to be like some determination of male or female. That's sort of that, binary choice in frankly, a non-binary world. But, how do we square those two?
Well, I think
those two statutes.
Sorry, I didn't mean to jump the gun there. I think that the department is attempting to square it by the manner in which it's housing Ms. Inscoe. So the statute 14844 makes a clear distinction reference to male and female. It's an older statute that the department has to figure a way to comply with in this, as Your Honor mentioned, a non-binary and changing world. That's why I referenced the difficult challenges of considering housing with a gender diverse population. But the way that that sort of circle is squared is by providing for separate quarters while also maintaining operational but while also sort of balancing the operational and security concerns that the department may have by keeping persons at certain types of facilities. Now those are subject to change. The petitioner is always free to request again, and there would be another review. And the DTARC does the hard work of going through hundreds of pages of records, seeking outside consideration for advice and counsel from other folks and other experts that may provide helpful information. But the DTARC has to be able and should be able to weigh all types of information beyond what appears in the birth certificate, because if not, and then 14844 ends up eating 14836. And there's no room for consideration of anything beyond what appears in the birth certificate. Now the petitioners...
So let me ask, say things could change. So for example, I think, in this record, there was review of the fact that the petitioner had been adequately accommodated, had not had problems, I think for several years in the facility where a petitioner already was housed. So for example, if things were to change, if there was a problem, or if there was a change in maybe the mental health care available at a facility, then there would be the possibility of saying, I need this reconsidered.
Yes, Your Honor. The department is, as I mentioned, it's a very fluid environment, having to control operations for a vast prison system like the North Carolina State Prison System. And the DTARC process is one that is specifically designed to address the kind of fluidity and the kind of dynamism that comes in play here. It is not uncommon for the DTARC to consider and reconsider requests by individuals after months or years pass or after there's a change in circumstances, absolutely. And the DTARC, it should be and does presently and should continue to be able to consider all types of changes in circumstances, risk profiles to the petitioner or to someone like the petitioner, or risk profile that the petitioner may present to others with where she's housed, or the ability to provide certain services at different facilities. So these are common factors and common considerations that come up and that are reviewed not just by the DTARC but by the prison system as a whole. And if this writ of mandamus stands, the department would be limited in certain respects from considering all of those types of issues. And the only time where they would be limited is in these scenarios where you have this unique situation of a gender diverse individual that's requesting a cross-gender facility transfer, and the department would be completely unable to consider anything beyond what appears in the birth certificate.
So,
Oh, please go ahead.
well, yes, you've got about a minute left before you hit rebuttal, so it seems like a great time to bring up the ancient writ of mandamus. But, if mandamus is not the proper remedy, what remedy should the petitioner have availed themselves of?
Well, I can't presume to speak to what the petitioner could or should be able to do, but I do know that there are ways in which the petitioner has and can continue to pursue internal grievances if she feels that her housing situation is putting her at a particular risk of harm. There's obviously legal recourse that she could take if she feels that there is that the risk of harm rises to a constitutional violation. But for purposes of writ of mandamus, this is not the appropriate way to sort of force a transfer to a different facility, because the decision to make a transfer is a discretionary decision. And the third element for a writ of mandamus is that the act—
But if there was, say, an abuse of discretion, hypothetical abuse of discretion, is there a process for judicial review within the system itself, or
within the prison system?
Or within the, statutory regime, the regulatory regime, administrative regime?
I think if there was an abuse of discretion by the prison system in denying a transfer, that might get over the third element hump of the writ of mandamus. But I think we still would have to get over the clear legal right, which is the first element. And I think the fact that we're having this robust discussion about what quartering means and how it's to be interpreted in various contexts is an indication that perhaps whatever legal right the petitioner has to be housed at any given facility, it's certainly not a clear legal right. So I think, to Your Honor's hypothetical, assuming that the other elements of writ of mandamus were present, if there was an abuse of discretion on that third element, that the act has to be ministerial and not discretionary, the caveat there is if it's discretionary and there's an abuse of discretion, then a writ of mandamus can hold. But I think a second caveat to that caveat is that the case law is fairly clear that in that scenario, it's that an order be issued for the department to make or for the respondent to make a decision, not to dictate what that actual decision is. If the decision itself, if a petitioner or a prisoner or litigant believes that their rights are violated by the decision, that is some other sort of constitutionally sourced rights, then they are permitted to file a claim trying to remedy that. And I'll reserve the remainder of my 3 minutes and 25 seconds for rebuttal.
Good morning, and may it please the court. My name is Elizabeth Simpson, and I represent the appellee, Miss Ashley Inscoe. I want to start by making clear that there is no sense in which Miss Ashley Inscoe's quarters are separate from male prisoners. She interacts with men every single day, all day long. She is, as the prison custody's witness said at trial, in a housing unit that houses other men. Men are within sightline, they're within touch, they're within shared space. Men can and do expose themselves to her. She lives in a dorm that houses 107 men and 1 woman. Her cell is unlocked most of the time during non-lockdown periods. And to be able to use the telephone, to use the shower, to use the day room, to get her food, to get medicine, to do her job assignment, or to recreate, she is surrounded entirely by men. At trial, Judge Shirley made an apt comparison to the Third Amendment. He asked rhetorically whether the Third Amendment about quartering soldiers meant that soldiers could enter your private home and use your living room, your kitchen, your bathroom, so long as they did not sleep in your bed. And of course, the answer to that is no. The Quartering Amendment does not permit that. Ms. Inscoe is not quartered separately from males. She is the only female at Nash Correctional Institution, and this is a facility that is designated solely for men. It only has men's quarters. It's not a matter of a prison. Like the Attorney General points out in his brief, in Central Prison, when it was first formed, they had a women's division of Central Prison. And at that time, there was a statute in the books that did not permit men and women to go in the same room. They had separate quarters at Central Prison for men and for women. They were quartered separately. So it's true, men and women can be housed at the same facility in North Carolina so long as they have separate quarters. For instance, The General Assembly does permit the setup that North Carolina Division of Adult Correction has at Anson Correctional. Right now, there are men's quarters and women's quarters at Anson. They both reside there in separate quarters, so in separate dorms, in separate blocks. They don't have one woman sleeping in a dorm that is designated for men, surrounded by 107 men. So in North Carolina, male and female prisoners do not mix. They don't have contact. They don't interact. They have entirely separate quarters because it's not college. Ms. Inscoe is a woman who is being housed in a men's prison dorm in men's prison quarters. The Commissioner of Prisons has not always taken the position that he's taking today. When he answered the original writ of mandamus, he admitted that it's a common sense proposition that it was his duty and his authority to house women with women and not in men's facilities. That is the correct answer. Ms. Inscoe is a woman, and that was found by competent evidence by Judge Shirley at trial. She has her certified North Carolina birth certificate, which registers her sex as female. And as Judge Hampson pointed out, that is prima facie evidence in North Carolina of the facts that it contains. Of course, the prison commissioner could have brought competent, reliable, admissible evidence to rebut that, but he did not do so. And now he concedes on appeal that Ms. Inscoe is a female. So that is established for purposes of this appeal, that she is a female person. The medical professionals that examined her were unanimous that she was a female. That includes the surgeon who performed a surgery to correct a genetic abnormality, and it included a prison psychologist, Dr. Herzog, who opined that she was a female as well and belongs in a female facility. The testimony at trial was just from administrators who had not examined her personally and did not have any personal knowledge of her sex. She does have XX chromosomes, so she has female chromosomes.
Now, I had a question about that.
Yes.
In the record, I believe it said that she had contended that she had that, but that the department had been unable to obtain medical records to confirm it, and additional steps are typically conducted before coming to that conclusion, and that petitioner was not comfortable with responding to continue conducting the test, so it was, and when it was referred to outside providers, the providers declined on grounds that testing was not medically necessary. So I was just not clear that it was something that was stated. There was the CT scan showing a fully formed prostate and male anatomy. So, I mean, I'm aware that obviously that condition exists. I just wasn't clear if it was established here.
I guess the way that Judge Shirley put it was that there was evidence that she had XX chromosomes, and there was no evidence on the other side that she did not.
Was that evidence simply her statement that had been identified in the past?
I can find the point in the record, but there is a lab test from California that reflected XX chromosomes, and then also there was several medical records referring to her intersex status. And that, of course, is a status that is shared by 1 in 2,000 people, you know, in the world. And in North Carolina, we don't have a gender marker or a sex marker that is intermediate or non-binary. So all of those people who are intersex are classified either as male or as female. And in this case, Ms. Inscoe was erroneously classified as male at birth, and then it was corrected by a surgeon, and she qualified for a new sex marker on her birth certificate under the general statute that's existed since the 1970s. So her legal sex is female as well.
Wasn't that subsequent to the orchiectomy?
Exactly. That was the reassignment surgery that was performed. The surgeon made the affidavit, and then she qualified for the sex marker update.
But it wasn't on the basis of having X chromosome, right?
Exactly.
Okay.
It was based on the opinion of a surgeon. So that is how the statute 130A-188B4 sex reassignment surgery. And so the surgeon swore that he performed that surgery and that entitled her to a new birth certificate in North Carolina. And that, of course, relies on objective fact of surgery. It's not based on gender identity or those sorts of things. And so those facts are all unchallenged by the prison administrators on appeal and are binding. So the statute does say the department shall provide quarters for female prisoners separate from those for male prisoners. That's a mandatory statute. It uses the term shall and is separate and apart from 148 36, which discusses the prison's vast discretion in housing people. The prison does have vast discretion in deciding where to house people and to make sure that it protects all people in prison as well as it can, and keeps them safe, right? And so as Judge Hampson mentioned, if the prison decides to move Ms. Inscoe to a female prisoner, they have vast discretion where to put her, what kind of housing unit, whether it's lockup, what kind of custody status, what kind of supervision she has. Those are all things that the prison can do. All the cases that the prison cites about discretion in terms of housing relate to those sorts of factors: programming, education, geography. Those are things that prisoners do not have any control over. The one thing that is mandatory under the general statutes is that male prisoners be quartered separately from female prisoners, and that is taken away from the discretion of the Department of Adult Correction. Now, in terms of the DTARC, which is an administrative body that is designed to sort of adjudicate questions where there is a mismatch, where the legal sex does not match the gender identity. Those are difficult circumstances that call for the exercise of discretion. But what Judge Shirley rightly found here is that this is not room for discretion because there is no mismatch. We have a legal sex marker that matches the gender identity, and it's conceded those things are true. And so it takes it out of the land of discretion and puts it into the mandatory statute 148-44.
But Judge Shirley also finds that there was no abuse of discretion by DTARC and PTARC in making its determination.
Exactly, because this particular statute is non-discretionary. So as long as someone has a legal sex marker that has not been rebutted, there's not been evidence presented that that legal sex marker is invalid for some reason, there is no discretion for the Department of Adult Correction. And so it's not something that DTARC has any jurisdiction over.
So, taking your point, if the statute itself is not discretionary in terms of separate quartering for male and female inmates, what discretion does the department have in determining how to quarter inmates separately? Understanding we don't have a definition of quarter itself in the statute. So what discretion does the, as the agency or the department charged with enforcing the statute have in making those kinds of determinations as to what constitutes separate quartering?
Well, I would say
At least
that
in the first instance.
the way in which they do it with every single other female prisoner in the entire state of North Carolina, which is they put female prisoners in female prison quarters, and those are dorms that are dedicated to women, and they're housing units that are dedicated to women. So it's not just one cell in a dorm that has 107 men and one woman, where that woman is sharing a telephone, sharing tables, food, restroom with men. They must house women in separate quarters. And so that looks like, for instance, Anson. They had, to accommodate their needs for space, at Anson Correctional, they have established some women's quarters and some men's quarters, and they do not mix. That's how they can handle it. Obviously, they can look at their population numbers and see how many men they have, how many women they have, what are their needs in terms of mental health, in terms of programming, in terms of education, in terms of work release, and establish whatever quarters they need to establish. But they may not take one woman and place her inside a men's prison dorm and have her live there with 600-some men. That's what they may not do. And I don't think that is a big thing to ask, and I don't think that's really divesting them of discretion. This is what they do every single day with every other woman in North Carolina.
So let me ask, if you take away the discretion, arguably, of the department to make determinations, you say, okay, birth certificate controls. But obviously, they have other things they have to consider in housing prisoners. So I'm going to give you a hypothetical. This is not petitioner's case here. But let's say you had a petitioner who had a very, very violent history of assault, who had, things happening that would make this, that the department's opinion is, based on things that have happened, it would be dangerous to the other women in the facility. So, but the statute says, must be in the women's facility. So the way that they would have to deal with that might be say, okay, she's going to be in the women's facility, but in solitary confinement to protect the other prisoners, which would seem to be a horrific solution to me. If they had that situation, is like, we're bound, you know, we don't have any choice, we must put her here, but we think it's going to be dangerous to other prisoners, so we're going to put her in solitary confinement. I mean, this gives them the discretion to say, we can put her in this facility and we can do this arrangement, which would balance the needs of all of the population. I mean,
Except that it violates the general statutes, right? Because the general statute is mandatory.
I mean, under that interpretation of the statute, you're saying that, yes, they would be stuck with putting that person in that facility and just deciding that their needs, based upon the situation, is that that person is going to have to be isolated.
If they thought that person was of such imminent risk that they had to be isolated to keep others safe, then they would have to make that determination. And that is the type of determination that they make every day in both the men's prisons and the women's prisons with some very dangerous people.
Sure.
But Ms. Inscoe is not a very...
Like I said, I'm doing a hypothetical.
Yeah,
I realize it's not her situation.
Right.
But we have to think about these things, right? You know, when we're looking at these cases.
And I think the other thing that you can note is that if, I think there may be some concern about somebody changing their birth certificate under a false pretense. And that's also a case where they can bring evidence to rebut it, right? It's just a prima facie evidence. And at trial, they did not bring any evidence to rebut the birth certificate. So they have that option as well. Their discretion is not tied in that way. But you would think that Ms. Inscoe is the most dangerous woman in North Carolina, the way that they have her locked up with 600 and some men, but she can't be, because their prison witness, the psychologist, Dr. Piper, referred to her as having a, quote, very good disciplinary record, and the own records in the DTARC refer to her as, quote, compliant. So she is not in on an extremely violent offense, on a murder, an assault. She's not in for sexual misconduct. The prison records list her actually as being at high risk of being a victim of sexual assault as a person who is intersex and a person who identifies as female, a person who is female in a men's prison. And she has been subjected to harassment, unwanted touching. When she was in prison in California, she was raped, and she was transferred to a women's prison in California as a result of that, upon realizing her intersex status. So, and the one sex offense the prison commissioner mentions was indecent liberties with a minor that occurred when she was 18 years old with a younger teen, and that was 25 years ago. So a quarter of a century, her entire adult life, no allegations of that sort have ever been repeated against Ms. Inscoe. And so the idea that to keep women safe, she needs to be housed with men does not pass the smell test. But regardless, they don't have the discretion to make that decision because the statute is absolutely clear. And I think that it distorts the meaning of quarters to think that a cell that is open to a cell, to a dorm with 107 men is truly separate. Going to the standard for writ of mandamus, which Judge Shirley correctly found that petitioner had met, the first element is that the party seeking relief has a clear right to the act requested. This goes back to the mandatory nature of the statute, the shall. But it does say that female prisoners shall be quartered separately from male prisoners, and that's a right that female prisoners have, and Ms. Inscoe is a female prisoner. The flip side of that, of course, is the respondent has a legal duty to perform the act requested, and he does have a duty to do this thing. It is sort of a deceptively simple argument, but the commissioner has a duty he has all this discretion to make all of these decisions about programming, about education, all of these things, but when it comes to male prisoners and female prisoners, they must be kept separate, and so he has a duty to do that. It's ministerial, it does not involve discretion, because in this case where the birth certificate and all the testimony of medical professionals who have examined Ms. Inscoe are that she's female, and she has a female gender identity, which they concede and admit, there is no discretion as to who she is or what is her sex. It's simply a fact that she is a female person. And so there's no reason to bring discretion in. There's no other female in the state in which the commissioner has come asking for discretion to place her in a men's prison dorm. The time to reform the act has expired, and it's actually gone on for years. Ms. Inscoe spent years in the DTARC trying to get her matter adjudicated, and the Wake County Superior Court, it was Judge Ridgway at that point, gave them one last chance to decide yet again what to do, and that time did expire over a year ago. And so there is no adequate legal remedy. So the question Judge Hampson had, where does Ms. Inscoe go if she does not have writ of mandamus? There is nowhere that she can go. There's no judicial review of the administrative decision that the DTARC makes. Now, there may be other civil rights suits or other forms of action that she could pursue in federal court or in state court, equal protection, that sort of thing. But the fact of the matter is there's a very simple statute in the books in North Carolina that protects female prisoners like Ms. Inscoe, protects them from being housed in a dangerous situation, a situation that's inherently dangerous.
But mandamus, it's such a kind of stark remedy, right? I mean, the classic mandamus situation is the department has failed to make a decision, right? And mandamus issues to compel a decision. It can't compel what decision? You would agree with that, I think.
That is the classic scenario, yes, but I think that the stark remedy, and Judge Shirley agreed with this, fits here because the statute is so very simple and clear that female prisoners shall be quartered separately from male prisoners, and Ms. Inscoe is a female prisoner. There's not, it's almost an absurd case, and I think that absent the, I think there's in the background this leaning on the fact that she is, quote unquote, as Mr. Rodriguez says, gender diverse, that she's an intersex person. But that is the status that affects 1 in 2,000 people. It is something that may not come to light until puberty, and something, frankly, that is handled much more adequately now than when Ms. Inscoe was born in 1980. But I think that discriminating against her because of that genetic abnormality is inappropriate, because at this time, medical professionals who've examined her and evaluated her have opined that she's entitled, under North Carolina law, to the female sex marker. And she has that female sex marker. The department has not been able to rebut it, and in fact now does not care to rebut it. They admit that she's a female. And so if it was any other female in the state, I don't think there'd be any question that she would be in a female prison dorm. She would be at Anson Correctional. She would be at North Carolina Correctional Institution for Women, or she'd be at Western Correctional. Those are where she would be housed. The prison doesn't come asking for permission to house females at men's facilities, absent this in the background, this gender diverse thing. But this intersex status is something that exists, and exists actually with more prevalence than we might think. And the fact that Ms. Inscoe's, did not have the health care that she needed until a late age, for all the reasons that, that entailed, does not mean that she should be treated differently, that she should be discriminated against and not get the protection of this very clear and simple statute. Doctors are experts, not administrators. They're asking for their administrators who never evaluated her, who've never met her before they came to court and testified about her, to be able to decide what she is, and for that to have more weight than her own surgeon, than the psychologist who actually sat with her and evaluated her and said, this is, quote, a female inmate, and she would be best served in a female prison. And we don't need to say that it has to be a separate facility. I think that is a little bit of a red herring, because of course Anson Correctional has women and men at the same facility, but they do need to be separate quarters. They need to be separate dorms. You can't put a woman inside a prison dorm with 107 men. It's not safe. It doesn't make sense. I would just conclude, if there are no more questions, by saying that the state is asking you to contort a clear and unambiguous statute. They want you to write an opinion saying that they can put any female in the state into men's prison dorms. Judge Shirley correctly saw that as an overreach by the Department of Adult Correction. They have a lot of discretion. They have vast discretion, and that's appropriate for them to make a lot of determinations that are very factual, and very nuanced, and very difficult, but this is not one of them. The court should follow Judge Shirley's reasoned and reasonable opinion and defer to the medical doctors, defer to the Vital Records Department, and not scaremonger about a person's gender diversity or mental health status. Thank you.
Thank you. Rebuttal?
Thank you, Your Honor. The petitioner's argument, the whole thing simply assumes a particular interpretation of 148.44. And this court reviews statutory construction issues de novo, and this court should reverse the interpretation of 148.44, and particularly the term quarter, to require the housing of a particular individual in a wholly separate facility. To do that, to get there, as I mentioned in the first time up here, you have to, or you necessarily have to, strip away any other consideration by the Department of Adult Correction and read into the statute of an interpretation of quartering that is not provided by the text of the statute nor supported by the dictionary definition of the term. A few other points I wanted to address before I run out of time. I believe this is correct. I don't know this to be 100% sure, but I believe it's correct that at Anson there are actually multiple facilities on the campus, and that the facility, the building that houses females, is a separate facility than the building that houses males. With respect to the assertion that in our answer we conceded where the petitioner should be housed, we referenced this in a footnote, I think, in our brief. That assertion, it overlooks that right before that allegation and response, there was a very specific allegation that Ms. Inscoe should be housed at a female facility that was denied. So that's a red herring. With respect to the prison psychologists and other individuals that Ms. Simpson mentioned, their opinions about where the petitioner should be housed or what the petitioner's gender or sex is, there's no indication that those individuals did the comprehensive review and consideration of the host of factors that the DTARC did. That is precisely why the DTARC is there and comprised of folks from different disciplines so that they can weigh all the relevant information, not just base their position on a particular clinical mental health encounter. A couple other record housekeeping issues. I believe also that there's a reference to a lab test from California in one of the medical records. I don't believe that you'll find in the actual record an actual lab test result itself. The DTARC is not there to determine or assess a mismatch between gender or sex or anything of the sort. DTARC is there to weigh requests by gender-diverse individuals, transgender individuals, intersex individuals for a variety of accommodations like a cross-gender facility transfer, which is what we are dealing with here. Writ of mandamus is not appropriate because this is a discretionary act, and even if it did apply because of an abuse of discretion, it could not be used by a court to require a particular action. So for those reasons, we submit that this court should reverse the writ of mandamus. Thank you.
All right. Thank you all for your arguments. And we will adjourn.